page 27, my lord. Same order, my lord.
Same as in the earlier
Yes, my
first half.
Yes.
But my lord, now even the B and C category is what he is requesting. Now we have only mop-up round and stray vacancy. Only those categories he'll be entitled. Even assuming that he will fall in any of those category, he can only
So that-
exercise this subject to the notification.
There was an order relating to that mopper.
Prior to that was prior to Willard the NRA quota being taken. Now that is also over. Now we have only mop-up and stray vacancy. In the event of any notification coming and permitting the petitioner to register, then only it can be considered.
So that is the rider in this order also.
That rider is there, but I'm only bringing to your lordship notice that he has come after the even NRA quota is also completed.
Why should we indicate all that?
Very well.
My lord, it is, my lord, for missing of exercising web option, my lord. Kindly, my lord, seeking consideration in the next phase of counseling, my lord. Order copy, my lord, page 29, my lord.
This was that further
before
observation.
I beg pardon.
This was that further observation in case university allows,
Yes, yes, Lord. That
her case will be considered in unfilled seat.
yes, Lord.
The
Yes,
same order in the previous one.
yes, yes. The same order
Yes,
will be here.
same order.
Yes,
This
my lord.
order in both.
Yes, Lord.
Copy
And
by today, my lord.
great.
Much of.
That before your lordship blood hear the learned advocate gender, that we want to request one thing, that we filed several limited applications blood on behalf of the backward class organizations. Lordship may give us blood some opportunity to make our submissions.
Yes.
Few lawyers, all will not be arguing, my lord. Pleading, your lordship is so gracious for us to consider some voice, my lord, sir. Some submission only, legal submission, your lordship may
Will-
consider. After the learned advocate general submits, my lord.
If
That's what.
Lord, my item number 159, my lord, I filed a categorization, but that is not heard yesterday. So that may be heard, my lord. Petition
Yes,
number
yes.
30503.
May please. My lord, I'll only just brush through, my lord, I'll not show any much of the documents, my lord, only to brush through because most of these documents were brought to your lordship's notice. Only to show to your lordships that how the sequence took place. Just see the sequence, my lord, I'll not trouble your lordships on anything. My lord, this is the basis, my lord, for the reservation for 42%. My lord, the first of the GO, if your lordship will please to see 18, this is for the taking, my lord, your lordship may just see the planning department taking up, my lord, the first paragraph, taking up a comprehensive door-to-door household survey, socio-economic zones, Telangana State Legislative Assembly resolution. My lord, these are resolution of the State Legislative Assembly. Telangana State Legislative Assembly has passed resolution as follows: that the House resolves to take up a comprehensive door-to-door household, socio-economic, economic, education, employment, political and caste survey of entire Telangana state as per the decision of the Council of Ministers on 4th February 2024, so as to plan and implement various socio-economic, education, employment and political opportunities for the amelioration of the backward classes, SC and ST citizens of the state and other weaker sections of the state. Government, after careful examination, hereby ordered to take up comprehensive door-to-door household survey, socio-economic, educational, employment and caste survey of entire state so as to plan and implement various socio-economic, educational, employment and political opportunities for the amelioration of the backward classes, ST citizens and of the state and other weaker sections of the state. Planning department is designated as the nodal department for conducting the survey. The survey shall be implemented within a period of 60 days. My lord, first aspect is, my lord, This is a resolution, a unanimous resolution of the assembly, my lord, with no objection from any political party. It was a unanimous resolution to take up this survey. My lord, this survey, my lord, your lordship will please see next page, is the resolution of the Council of Ministers. Next page. Taking up a comprehensive door-to-door household, my lord, I'll just apply item number 21. Educational, economic and political and caste survey of entire Telangana, placing the proposal before the Council of for approval of household survey form, timeline and budget regarding. My lord, this survey report was submitted. Your lordship may kindly see the next page. Down below, my lord, report of the socio-economic, educational, employment, political and caste survey 2024 and relevant data tables, placing the report before the Council of Ministers for approval. Next, my lord, overleaf is the resolution of the assembly. My lord, next page is the resolution of the assembly, and my lord, this resolution, Telangana government has conducted a comprehensive door-to-door socio-economic and educational, employment, political and caste survey. This has thrown light on the relative economic, social, educational, employment and political status of different castes in the state. The Telangana government is committed to the development of backward classes, scheduled castes, scheduled tribes and other weaker sections of with a sincere commitment, the government aims to design favorable and affirmative policies to reduce the disparities among various castes in the state. Since independence, for the first time, the Telangana government implementing this historic decision is exemplary. The House of Legislative Assembly resolves to urge the central government to conduct a nationwide comprehensive door-to-door survey on social, economic and so on. My lord, this report of the survey was accepted by the assembly unanimously. I'm just telling it to your lordship because, my lord, a unanimous resolution of the assembly is nothing but, my lord, the political will of the people. My lord, people at large. It's a unanimous resolution. All these, my lord, the resolution to conduct the survey and the resolution accepting the survey is a unanimous resolution of the assembly, my lord, which reflects, my lord, the resolution of the people at large through their representatives. My lord, this is a survey conducted on a door-to-door basis. My lord, some of the objections which are raised is that, my lord, the report should have been placed before the, my lord, should have been placed. We should have been given an opportunity. My lord, this is a door-to-door survey. My lord, everybody here, my lord, except for 2% of the, my lord, population in the state, 2% of the population in the state did not fill their forms. Otherwise, my lord, the entire state has filled their forms. Therefore, my lord, everybody knows what is there in the survey. If there is a dispute from the petitioner saying that, my lord, this survey showed that it is 57.6% as backward class population. This survey showed, my lord, that was shown to your lordships. 57.6%. My lord, if in the event the petitioners were to dispute that it is not 57.6%, if it is something else, my lord, there would have been, my lord, they would have shown prejudice to your lordship, saying that my report is different, our estimate of BC population is different, therefore we should have been given an opportunity. Then that issue would have arisen. That issue is not there. There is no dispute on the petitioners or from anybody that the BC population is 57.6%. On the basis of this survey, on the basis of, my lord, empirical data that the BC reservation is 57.6%, my lord, 42% is fixed. My lord, the issue of showing anybody the report, my lord, does not arise. It is on the basis of this survey, where the survey showed on a door-to-door, my lord, after enumerating on a door-to-door basis, the BC population came to 57.6%, which is not in dispute by anybody. My lord, when it is not in dispute by anybody, asking for a copy of the report, my lord, would be, my lord, it's a futile thing, my lord, being raised before your lordships for nothing. If they would have said, my lord, our report is something, the report, my lord, it is population is not 57.6%, it is something else, my lord, they would have raised an issue before your lordships that these reports should have been given to them. None of that thing is raised. So 57.6% remains the BC population of the state, and, my lord, accordingly 42% is fixed for the purpose of providing reservation. Therefore, my lord, the fixation of 42% cannot be found fault because it's on the basis of an empirical data, my lord, in the most scientific manner which is conducted. It's on a door-to-door basis, my lord, a campaign was conducted. Pursuant to this, my lord, the state, my lord, enacted that bill, my lord, which was shown to your lordships, my lord, bill number 4, which your lordships have seen. This bill was passed, my lord, I'll stop saying, my lord, bill, my lord, this resolution of the assembly for the purpose of implementing 42% is a unanimous one. Bill number 4, my lord, it was passed on to your lordships yesterday itself. Bill number 4.
It was shown by Mr. Singhvi yesterday.
Yes, my lord. Bill number 4. I'll just read that for your
That
lordship.
yellow. No, this one.
Book file.
Yellow one.
That's mine. Don't touch that. It's not there. My lord, bill number 4, my lord, if your lordship will please to see. The bill to provide for the reservation of seats in rural and urban local bodies in the state for the backward classes of citizens in the state of Telangana and for matters connected therewith or incidental thereto. एक तो जो beg your lordship's pardon, my lord, instead of going to,
Got it.
I'm sorry. I just read to your lordships the heading. My lord, this legislation is passed by the state. My lord, your lordships may pardon me for using this word repeatedly because, my lord, it throws some amount of the light on the whole of the case. My lord, this legislation was passed unanimously by the state with no political party opposing it. My lord, it's a unanimous resolution. This legislation is passed. My lords may kindly go to 4 for once, my lord, overleaf, my lord, section 4. Only to show to your lordship, my lord, it's notwithstanding. There's a non-obstante clause. Notwithstanding anything contained in any other act for the time being in force, other judgment, decree or order of any court or other authority, having regard to the social, economic and political backwardness of the backward classes of citizens and inadequacy of their representation in rural and urban local bodies who constitute the majority of the total population of the state of Telangana, the reservation in respect of the rural and urban local bodies in the state for the backward classes of citizens shall be 42%. My lord, this was,
Yes.
but this is a unanimous resolution which said that we would provide 42% in all political local bodies, both rural and urban local bodies. My lord, this is reserved by the president for the president's assent on 30/3/2025. My lord, 30/3/2025 onwards till date, my lord, since the assent is not given, my lord, in view of the judgment of the state of Tamil Nadu versus governor, my lord, there is a deemed assent in respect of this act. My lords may kindly pardon us, my lord. In the event the assent is given, my lord, these will be gazetted or notified again as act number so and so. My lord, since the assent is not given and, my lord, by virtue of the judgment of the Honorable Supreme Court, by a judicial pronouncement, my lord, this has become an act. A further notification will not be necessary. By a judicial pronouncement, my lord, this is an act now. Hence, my lord, I would not like to trouble your lordships on the repeated showing.
This has been argued
I'll just read below paragraph 250 for your lordship's concern.
This was read by Mr.
Yes.
Singhvi yesterday.
Not trouble your lordships. Therefore, my lord, this is now an assent. My lord, there is a deemed assent, and my lord, in view of the deemed assent, this is now an act. Therefore, my lord, it is an act by a pronouncement of the Honorable Supreme Court of India. Therefore, my lord, this becomes an act, and a further notification would not be necessary, because in the event an assent is given, my lord, we would have, my lord, notified it. It is an assent given, and my lord, this has now become an act by virtue of the pronouncement of the Honorable Supreme Court. Therefore, a further, my lord, notification of this would not be necessary, my lord. Or it's not, my lord, contemplated, because it's by virtue of a judicial pronouncement, this has become an act.
Very well.
My lord, then came, my lord, the amendment to be made to 285A. My lord, your lordships have seen 285A of the Panchayat Raj Act, which says that, my lord, there's, my lord, why that was placed in the 285A, my lord. My lord, 285A. Reservation of states, Panchayat Raj Act.
Yes.
Panchayat Raj Act, my lord, if your lordships will please to see 285A, should be at page 184. Similar. 285A, my lord, it is by way of an amendment in 2019. Reservation of seats in pursuance of the judgments of so and so, 50% vertical reservation in favor of SC/ST SOP should not be breached in the context of so and so. Notwithstanding anything contained in so and so, elsewhere in the Act providing for reservation in favor of scheduled caste, scheduled tribe, the seats of offices to be reserved for backward classes shall be so determined, duly keeping in view the requirements of reservation in respect of SCs, STs therein, and the total number of seats offices reserved for SC/ST shall not exceed 50% of the total number of seats, or as the case may be, the offices in the respective local bodies in the manner prescribed. This amendment came, my lord, on 15/12/2018 by way of an Act 4. My lord, these Act 4, my lord,
This was in pursuance to which judgment? It doesn't refer to that judgment.
No, it doesn't refer, my lord. It
But
just says
basically, what should we understand? Krishnamurti.
should be Krishnamurti or I don't know, should be Krishnamurti. My lord, there would never be a legislation which imposes upon themselves any percentage. This is a negative section which is seen for the first time, that we will not give anything more than 50. We will normally say we give 42, we give 30, we give, earlier it was 34. If your lordship will please to say section 9, my lord, which is referred here. Section 9 says the reservation for backward classes would be 34%. This is the first time, my lord, in order to get over all those sections, my lord, this section is inserted. This section, my lord, is in the most negative form which can be seen. And it was there, my lord, it was brought onto the statute, my lord, in 2018. My lord, the state, my lord, by way of an ordinance dated 10/7/2025, my lord, this ordinance was, my lord, sent to the Honorable Governor, my lord, which again was sent to the President. My lord, at 285A, your lordship will get at number 125, my lord, in that last page, my lord. What was sought to be amended? Last but one page, my lord, last, if your substitution of section 285A, my lord, last but one page, my lord, 124 last. In the Telangana Panchayat Raj, for the section 285A, the following shall be substituted, namely, 285A, notwithstanding anything contained in sections 9, 7, 146, so and so, and elsewhere in the Act, providing for reservation in favor of scheduled castes, scheduled tribes, and backward classes, the seats and offices to be reserved for backward classes shall be, as may be notified by the government from time to time, having regard to the demographic and levels of political backwardness and inadequacy of representation on the basis of empirical data, keeping in view the requirement of reservations in respect of scheduled castes and scheduled tribes. My lord, this amendment sought. My lord, that negative thing, my lord, which came in 2018 that will restrict to 50 is alone removed. Nothing else is mentioned here. My lord,
Yes.
my lord, this is dated 10/7/2025, my lord. My lord, it was sent to the Honorable President for the assent on 26/7/2025.
26/7,
26/7/2025.
sent to the president.
Yes, on 26/7/2025 for the presidential assent. My lord, since the Legislative Assembly was constituted, my lord, after this amendment was sent, after this, my lord, ordinance was sent to the, my lord, the presidents for assent. My lord, the Telangana's, my lord, the Legislative Assembly by a unanimous resolution wanted to amend these by way of an act. 285A, they wanted to make it an act because the assembly was in session. My lord, on 31st August 2025, on 31st August 2025, this legislation was passed. This was on 31st August 2025, my lord. My lords may kindly, not to trouble your lordships, my lord, your lordships may see the statement and objectives, my lord, and reasons at page 3. Not read the whole thing, my lord. The para 3, if your lordship will please. The said commission, my lord, the commission under GO 49 above, after completing its study in accordance with the triple test laid down by the Honorable Supreme Court of India, submitted its report on so and so, recommending reservation for backward classes, local body wise. My lord, it is done local body wise, my lord. I'll bring it to your lordship's notice. The saying that 42% is across the state is not correct. It is done local body wise, my lord, each local body. My lord, para 4 here, my lord, the government of Telangana had earlier, with the approval of both the houses of legislature, undertaken a socio-economic, education, employment and caste survey, YDGO number so and so, and the findings of the survey were submitted before the Council of Ministers. Survey was accepted and the backward classes population is also given, my lord, across, my lord. This is the objects and reasons basing on which, my lord, this 285A, my lord, was sought to be amended, my lord, by way of an act. My lord, this also was sent to the Honorable President, my lord, His Excellency, the Excellency President for assent. My lord, I would like to bring to your lordship's notice, at the time, my lord, when 285A was amended in 2019, my lord, that is Act 4 of 2019. Act 4 of 2019, my lord, the amendment was done. It was not sent to the President for assent.
This one was also passed unanimously.
Yes, my lord, unanimously. Unanimously, without any opposition from any political party. Therefore, the credence to all these things, my lord, this is the unanimous will of the people of the state through their representatives. My lord, these I am only bringing it to your lordship's notice. That's Act 4 of 2019, which was passed by the then assembly. Act 4 of 2019 Act further to amend the Telangana Panchayat Raj Act. Overleaf, if your lordship will see, this is 285A, which was amended.
Right.
This is the amendment, my lord, which was brought in 2018 after the assembly passed this resolution. My lord, this was assented by the governor. My lord, this is assented by the governor. When this amendment is assented by the governor, my lord, the subsequent amendment, my lord, which was also passed by the legislature, ought to have been sent. This is not necessary for the reservation by the president.
Just for understanding sake, which are the nature of bills which are required to be referred to the
Okay,
honorable
my lord,
President?
I'll bring that to the constitution. My lord, only wherever there is repugnancy. My lord, mainly either repugnancy or my lord concurrent list. Other than that, nothing. State union has its own list, state has its own list.
Because
Insofar as panchayat, I'm sorry.
Because 243 D and T, they sub article 6 says state legislature.
Yes.
So there is no repugnance with that power, with the
Not-
power exercised by the state legislature.
Not remotely also.
In fact,
Apart
it
from
is
I'm
in
great.
conformity with what
243 D6, my lord, as my 243 D6, my lord, as your lordship have, my lord, pleased to, my lord, taking the cue from there, my lord, apart from 243 D6, which says it's the state's prerogative, and my lord, the jury, my lord, the legislative competence of the state is not an issue now here. My lord, apart from that, my lord, the entry 5 of list 2, my lord, is Panchayat Raj. Local bodies, my lord, fall within the list 2 only. List entry 5. Entry 5 of list 2, my lord, local governments and including village administration. There is no dispute on the fact that the legislative competence of the state is not there. Whereas the legislative competence of the state is there. My lords, I am grateful to your lords. 243 D6 says it's state legislature. Therefore, any law which is made, my lord, is here within the state only. And my lord, the assent of the president is not necessary. In that circumstance, and more so, my lord, 285A, my lord, when it was amended by in 2018, my lord, the assent of the governor was given. My lord, similar assent should have been given now also.
So now, after that bill has been sent to the governor and the ordinance was promulgated in July,
Yes,
life of an ordinance is for 6 months.
6 months.
So now that ordinance remains in force because of the passing, or it has merged into the bill now?
My lord, since the assent in the subsequent act is not given, my lord, it is still in force.
This is a legal.
Still in force. Because, my lord, if in the event this legislative, my lord, this bill of 14 of 2025, my lord, of the legislature pursuant to the ordinance, my lord, was not given assent, ordinance is in place. My lord,
This
In the-
also says that the last sentence of, say, 2019 amendment says the ordinance stands repealed.
yes,
So similar kind of a sub clause would be there if the assent is received and it is notified.
yes, that's. Therefore, my lord,
So therefore you say that by virtue of the amendment carried out by the ordinance, the legislature has agreed to make the necessary change in 285A.
it should be taken that it is on, my lord, it's now in vogue and it is now, my lord, so much is said, my lord, in state of Tamil Nadu versus governor. My lord, here, in the earlier term when 285A was amended, my lord, the assent is there. So similar
So that
assent
we
is deemed to
understand.
be there now.
Except that 1 month period was not over
My lord,
as
from the-
against this Panchayat Bill 31st August,
Yes.
the impugned GO is of say 26th September perhaps.
Yes,
So that 1 month period for that deemed assent.
but ordinance is there,
So ordinance would cover the.
field now. My lord, your lordships have seen 243 D6 and 240 T6 for urban bodies. my lord, which says that my lord, I'll just read that for your lordship's consideration. One, my lord, the Parliament, in its wisdom, never thought that there should be any restriction on it. 243D6 and 243T6. I'll just read. Krishnamurti యొక్క జీఎన్ those parts ఉన్నాయా? On searching, you tell to there it is. Look at it, I'm trying to force with you people. ఉంటుందా ఏదో నాకు ఇంత చూడ సూపర్ విన్నారా వాళ్ళకి చెప్పండి సూపర్ మధ్యలో Okay. My lord, I'll just read, my lord, 3 paragraphs of Krishnamurti which were not read to your lordships. One which were not read only.
We have it here itself. Which paragraph?
Para 51, my lords, may kindly see.
It's,
51, my lord, at page 224. Para 51, my lord. The nature and purpose of reservations in the context of local self-government is different from that in higher education and public employment. My lord, pausing here, my lord,
We have this judgment in the compilation submitted by. So,
This is SCC.
SCC part is there with us.
This is also,
No.
this is SCC.
So para 51 starts before addressing the
Yes,
contentious.
my lord, yes. I just read the, my lord, the heading, my lord. I just read the heading for your lordship's consideration. The nature and purpose above that, my lord, reservations of in the context of local self-government is different from that in higher education and public employment. My lord, the court said what is applicable for higher education and public employment is not applicable insofar as reservations for political bodies are concerned. Therefore, my lord, my contention before lordships is that 50% cap, which is borrowed from Indira Sawhney, would not be applicable here. The court itself said the higher education and employment reservations which is provided there is not applicable insofar as political reservations are concerned. Therefore, borrowing 50% from, my lord, Indira Sawhney, my lord, may not be correct. My lord, para 51, I'll just read for your lordship's concern. Before addressing the contentious issues, it is necessary to examine the overarching considerations, overarching considerations behind the provisions for reservation in elected local bodies. At the outset, we are in agreement with Mr. Rajiv Dhawan suggestion that the principles that have been evolved for conferring the reservation benefits contemplated under 15.4 and 16.4 cannot be mechanically applied in the context of reservations enabled by Articles 243D and 243T. In this respect, we endorse the proposition that Articles 243D and 243T form a distinct and independent constitutional basis for reservation in local self-government institutions, the nature and purpose of which is different from the reservation policies designed to improve access to higher education and public employment as contemplated under Articles 15.4 and 16.4 respectively. Specifically, with regard to the unviability of the analogy between 16.4 and 243D, we are in agreement with a decision of the Bombay High Court reported in Vinayak Rao Gangaramji Deshmukh versus PC Agarwal. That case involved a fact situation where the chairperson position in a panchayat was reserved in favor of scheduled caste women in the course of upholding this reservation, it was held as follows. Now that the 73rd and 74th constitutional amendments, the constitution of local bodies has been granted, a constitutional protection and Article 243D mandates that a seat be reserved for the scheduled caste and scheduled tribe in every panchayat, and clause 4 of the said Article 243D also suggests that the offices of the chairpersons in the panchayats at the village or any other level shall be reserved for the scheduled caste, the scheduled tribes and women in the manner in the legislature of a state may by law provide. Therefore, the reservation in the local bodies like the village panchayats is not governed by 16(4), which speaks about the reservation in the public employment, but a separate constitutional power which directs the reservation in such local bodies. We are, of course, aware of the fact that some decisions in the past have examined the validity of reservation in local self-governments by applying the principles evolved in relation to education and employment. In this respect, we are in partial agreement with one of the submissions of Rama Joy, that the nature of disadvantages which restrict access to education and employment cannot be readily equated with disadvantages in the realm of political representation. To be sure, backwardness in the social and economic sense does not necessarily imply political backwardness. However, the petitioner's emphasis on the distinction between selection in case of education and employment and election in case of political representation does not adequately reflect the complexities involved. It is, of course, undeniable that in determining who can get access to education and employment, due regard must be given to considerations of merit and efficiency, which can be measured in an objective manner. Hence, admissions to educational institutions and the recruitment to government jobs is ordinarily done through methods such as examination, interviews, or assessment of past performance. Since it is felt that the applicants belonging to SC, ST, OBC categories, among others, are at a disadvantage when they compete through these methods, a level playing field is sought to be created by way of conferring reservation benefits. In the domain of political participation, there can be no objective parameters to determine who is more likely to get elected to representative institutions at any level. The choices of voters are not guided by an objective assessment of a candidate's merit and efficiency. Instead, they are shaped by subjective factors such as the candidate's ability to canvass, support, past service record, professed ideology, and affiliations to organized groups, among others. In these contexts, it is quite possible that candidates belonging to the SC, ST, OBC categories would demonstrate these subjective qualities and win elections against candidates from the relatively better off groups. However, such a scenario cannot be presumed in all circumstances. It is quite conceivable that in some localized settings, backwardness in the social and economic sense can also act as a barrier to effective political participation and representation. When it comes to creating a level playing field for the purpose of elections to local bodies, backwardness in the social and economic sense can indeed be one of the criteria for conferring reservation benefits. It must be kept in mind that there is also an inherent difference between nature of benefits that accrue from access to education and employment on one hand and political representation at the grassroots levels on the other hand. While access to higher education and the public employment increases the likelihood of socio-economic upliftment of the individual beneficiaries, participation in local self-government is intended as a more immediate measure of empowerment for the community that the elected representatives belong to. The objectives of democratic decentralization are not only to bring governance closer to the people, but also to make it more participatory, inclusive, and accountable to the weaker sections of society. In this sense, reservation in local self-government are intended to directly benefit the community as a whole rather than just the elected representatives. It is for this very reason that there cannot be an exclusion of the creamy layer in the context of political representation. There are bound to be disparities in the socio-economic status of persons within the groups that are intended beneficiaries of reservation policies, while the exclusion of the creamy layer may be feasible as well as desirable in the context of reservations for education and employment. The same principle cannot be extended to the context of local self-government. The level of panchayats, the empowerment of the elected individual is only a means for pursuing the larger end of advancing the interests of weaker sections. Hence, it would be counterintuitive to exclude the relatively better off persons among the intended beneficiaries from the reservation benefits that are designed to ensure diversity in the composition of local bodies. It is quite likely that such persons may be better equipped to protect the interests of their respective communities. We can now attempt to provide answers to the contentious issues. My lords, we are pleased to see that reservations, my lord, the court thought that reservations are a necessary factor for the purpose of uplifting the weaker sections, because a political person, my lord, who on the basis of reservation gets elected will address the village and the weaker sections in a better manner, my lord, is the reason for these reservations to be provided. And in the face of, my lord, the population of 57.6% for weaker sections, my lord, 42% cannot be said to be excess. My lord, your lordships have seen para 65 for once, my lord. I'll just read that, my lord, only para 65. Wherein, my lord, 65, my lords will only see the Sri Rajiv Dhawan had contended that since the context of local self-government is different from education and employment, the 50% ceiling for vertical reservations, which are prescribed in Indira Sawhney, cannot be blindly imported, since that case dealt with reservations in government jobs. It was further contended that the same decision that recognized the need for exceptional treatment in some circumstances, which is evident from the following words. From the above discussion, para 809 of my lord Indira Sawhney, the irresistible conclusion that follows is that the reservations contemplated in clause 4 of 16 would not exceed 50%. While 50% shall be the rule, it is necessary not to put out consideration certain extraordinary situations inherent in the great diversity of this country and the people. It might happen that in far-flung and remote areas, the population inhabiting those areas might, on account of their being out of mainstream of national life and in view of conditions peculiar to and characteristic to them, need to be treated in a different manner. Some relaxation in the strict rule may become imperative. In doing so, extreme caution is to be exercised and a special case made out. My lord, here your lordships have seen from para 151 to 57, my lord, the court thought that reservations for local bodies is a necessity, and my lord, increasing that also would be necessary. More so, my lord, when there is proper empirical data. My lord, in all these reservation cases which have been brought to your lordship's notice, right from Balaji till date, my lord, did not have the empirical data, my lord, which is collected now by the state of Telangana. For the first time in this country, an empirical data of this nature has been collected, which clearly shows what is the percentage of each of the, my lord, communities. Therefore, each of the communities, even within the backward classes, even within the SCs, even within the STs and the open category, all the caste survey is done, my lord. From out of that survey, which was scientific, forensic in the best way, my lord, 57.6% is the population of the BCs. My lord, therefore, my lord, that formed the basis, my lord, for giving reservation to an extent of 42% for the backward classes. My lord, one other section, my lord, which I would like to bring to your lordship's notice is 243O also, if your lordship will please. 243O of the Constitution. Good to the last word. 243O once. 243O, barred to interference by courts in electoral matters. Notwithstanding anything in this constitution, the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies made or purporting to be made under Article 243K shall not be in question in any court. No election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as is provided for and by under any law made by the legislature. My lord, this law cannot be questioned, my lord. 243O is an absolute bar, my lord, for entertaining any of these cases. More so, my lord, when the election notification is issued. My lord, election notification was issued, my lord. You just show the notification and bring to your lordship's notice that this is the notification. My lord, there's some amount of dispute that this is not a notification at all.
जो है वो तो कोई इलेक्शन तो प्रोसेस नहीं करता तो फिर रिजर्वेशन
My lord, you
प्रोसेस में उसके बाद तो फिर उसकी सब
lords have seen the notification, if your lordship will please to see. In exercise of the powers conferred under 243K of the Constitution, my lord, 243K, my lord, cannot be interfered. 243O says, my lord, 243K, anything under 243K, my lord, is a bar, my lord, for the courts to interfere. Of the Constitution of India and Section 197 and 198 of Telangana Panchayat Raj Act, the State Election Commission, Telangana hereby calls upon the registered voters of all Zilla Parishads and all. Overleaf is also there, my lord. I'll just only to bring to your lordship's notice that this is a notification issued by the State Election Commission. My lords may kindly say, my lord, these sections are, my lord, they are shown here. My lords may kindly see the Panchayat Raj Act, my lord, Section 197 for once. One 197(6), if my lord, 197, my lord, powers and functions of the State Election Commissioner. 197, my lord. My lords may kindly go to 6, my lord. The State Election Commission shall issue the notification and schedule for general elections and elections for casual vacancies in all Panchayat Raj institutions. The schedule and the dates on which the elections will be conducted shall be decided by the State Election Commission in concurrence with the state government, which has to consider matters pertaining to law and order situation, internal security, availability of police, security personnel, home guards, central armed forces, logistics and their deployment availability, and procurement. My lord, this is section 6, the subsection 6 of 197. My lords may kindly go to 198. For the purpose of holding elections to fill ordinary or casual vacancies, the State Election Commission shall, my lord, 198, my lord, shall by notification under subsection 6 of section 197 published in the Gazette call upon such date, my lord. 198, my lord. For the purpose of holding elections to fill ordinary casual vacancies, the State Election Commission shall by notification under section 6. But this is the notification which is issued. My lord, 243O, my lord, is a complete bar, my lord, for any sort of interference at this stage, my lord, after the notification is issued. Your lordship may solve. My lord, 2006 5 ALD, my lord, a division bench of this honorable court, in a situation of this very same nature, my lord, held, my lord, my lord, I'll just bring this to your lordship's no consideration. My lord, this copy, my lord, will just pass.
Just you articulate whatever was formulated in that.
But I'll just show by that time, my lord, I'll be able to show to your lordships one of the contentions which is raised is in so far as reservations for BCs are concerned, you took the, my lord, survey, my lord, the socio-economic survey which is done for the purpose of fixing the reservations for backward classes. While for SCs and STs, you took the census of 2011 is one of the contentions that was raised. My lord, there is a constitutional, my lord, requirement that insofar as SCs and STs are concerned, you will have to relate yourself only, my lord, to the census which is available. The only census which is available now, my lord, is the census of the central government of 2011 only. My lord, after 2011, my lord, census is not conducted across the country. Therefore, what is available is only
In the general census, the census of different castes are not
no,
undertaken.
only SC,
Only SC.
Only SC. Therefore, my lord, the need for this survey which was conducted by the state government is virtually a census. My lord, what we conducted was virtually a census, taking a cue, my lord, from the survey which is done by the state of Telangana. My lord, the central government has now announced that even in the census which is going to take place now, the caste of each of the, my lord, individual citizen of the country would be recorded. That means, my lord, backward classes would also form part of the census now, tomorrow, whenever the census comes. But as is for the state of Telangana is concerned, my lord, we have conducted the census. Virtual census has conducted. And which got this, my lord, backward class, my lord, so we have got for each of the class, my lord, for backward classes, it is 57.6%. First, basics reservation, 243D. No. My lords, may kindly take 243D for one.
Yes.
My lord,
I think you
243D,
have
if my lords.
covered most of the
243D, if your lordship will see for once, insofar as the census thing is concerned, it is contained in 243D. Now, seats shall be reserved for scheduled castes and scheduled tribes in every panchayat, and the number of seats so reserved shall bear as nearly as may be the same proportion to the total number of seats to be filled by direct elections in that panchayat as the population of the scheduled caste in that panchayat area or the scheduled tribe in that panchayat area bears to the total population of that area, and such seats shall be allotted by rotation to different constituencies in a panchayat. Insofar as, my lord, scheduled castes and scheduled tribes, it says proportion to the population. And, my lord, how the population is to be looked into is there in the definition itself. It 243F. My lord, your lordships have seen 243D for once. 243D is, my lord, what I read to your lordships are seats for the SCs and STs in respect to their population. 243D, A, B, my lord, your lordships have seen.
yes.
And, my lords, may kindly go to 243F, population, definitions, my lord. Population means the population as ascertained at the last preceding census of which the relevant figures have been published. Insofar as SCs and STs are concerned, we should have to go only to the census population.
Yes, learned AG. So,
My lord, it is 2006 5 ALD, my lord, for the
sir, we have understood that proposition. So, these
My
things
lord,
can
your
be.
lordships may kindly go to my lord. I'm just showing to your lordships as to what was in issue at page. I'll only read 2 or 3 paragraphs maximum, my lord. Your lordships may kindly go to the first paragraph. Whether in exercise of power conferred upon it under
The,
226 of the
the
Constitution.
manner in which hearing in this interim application is going on, we could have well delivered the judgment itself.
My lord, here, my lord, the court specifically said even, my lord, after the writ petitions were filed, my lord, before the notification. In this case, my lord, which I passed on. The writ petitions were filed before the notification, and after that, my lord, notification was issued. Court said no matter what, there is an absolute bar in 243O. Only one para 49, my lord, if your lordship will please to see
What
the
was
court's.
under challenge?
My lord, the challenge was to the notification
Notification of?
of the for the Panchayat Raj, for elections to the Panchayat. Therefore, my lord, I'll just read that. Whether in exercise of the powers conferred upon it under 226 of the Constitution of India, the High Court can, notwithstanding the bar contained in 243O of the Constitution, entertain challenge to the reservation of the offices of Sarpanchas of Gram Panchayats in. Sorry, my lord.
Mr. AG, please give the
Some
reference.
misplaced somewhere.
AG garu, please give the reference so that we'll.
Is actually.
Copies are not served, but just give a reference so that.
SEC
2006 SCC online AP 658. And equivalent is 2006 5 ALD 409.
Obliged, obliged.
2006 5 ALD 409.
We make note of.
This first paragraph may be necessary, my lord, for your lordship's consideration. Whether in exercise of the power conferred upon it under 226 of the Constitution of India, the High Court can, notwithstanding the bar contained in 243 of the Constitution, entertain challenge to the reservation of the offices of Sarpanchas of Gram Panchayats.
Yes.
Yes, first paragraph itself. Reservations to the offices of the Sarpanchas of the Gram Panchayats in Mangapet Mandal, Warangal district in favor of the members of the scheduled tribe and pass an order which will have the effect of stultifying the process of election. Is the question which arises for consideration in this petition filed by so and so and others, 41 others, for quashing order dated 24/6/2006 issued by the Deputy District Election Authority and Revenue Divisional Officer, Mulugu, Warangal district. My lord, thereafter, my lord, it is the facts, my lord. Your lordship may kindly go to para 17. My lord, there might be a change in the numbers. 17, my lord, para 17. We may now notice, my lord, please. It is 17 in ALD, my lord. I'm sorry.
Yes, yes. Para 16, it is in this.
Yes, I'm sorry, my lord. We may now notice the judgments of the Supreme Court in which articles 329, 243O, 243ZG. My lord, 243O is in respect of panchayats, 243ZG is in respect of urban bodies. Have been interpreted in NP Ponnuswamy versus Returning Officer, Namakkal Constituency, 52 Supreme Court. Constitution bench of the Supreme Court considered The ambit and reach of 329B, which is pari materia to Article 243OB and 243ZG. In that case, the appellant was one of the persons who had filed nomination papers to Madras Legislative Assembly from Namakkal constituency of Salem district. The returning officer rejected his nomination paper. The appellant moved the High Court by filing 226 Constitution of India and prayed that the quashing of the order returning officer and for issue of the mandamus for inclusion in the name of the list of valid nominations. The High Court dismissed the writ petition by observing that it did not have the jurisdiction to interfere with the order of the returning officer. On appeal, the Supreme Court interpreted the word election appearing in so and so. My lords, that's the interpretation which is given. My lords may kindly go to para 49. 49, my lord.
Yes.
The propositions which can be culled out from the above noted judgments of the Supreme Court, this court and of the division bench of the Gujarat High Court are, well, that would be 48 for your lordships.
Yes, yes.
The word election appearing in 243O of the provisions contained in 1994 Act and the rules framed thereunder bears larger connotation. It embraces and includes all steps commencing from the date of notification by the competent authority whereby the electorates are called upon to elect sarpanchs and ward members and ending with declaration of the result, reservation of offices of sarpanch and wards in favor of scheduled caste, scheduled tribes, backward classes and women, preparation, printings, publication and electoral rolls, provisional, filing of nomination papers, scrutiny of nomination papers, withdrawal thereof, publication of the list of eligible candidates, allotment of symbols, appointment of election agents and conduct of poll, counting of votes, declaration of results and other ancillary steps taken for the purpose of holding elections fall within the ambit of term election. 243O, my lord. Second, the bar contained in 243O, which begins with non-obstante clause, debars all courts from entertaining any challenge to law relating to delimitation of constituencies or allotment of seat made or purporting to be made under 243K or elections to the panchayats. These bar also operates against the High Court's power of judicial review under 226. The court went on to hold, my lord, that you cannot interfere, and my lord, the writ petition was subsequently dismissed.
Yes. Yes.
My lord, in view of the fact, my lord, these has arisen, my lord, before this honorable court for the first time, where, my lord, a reservation is made basing on a survey which is conducted on a door-to-door basis across the state, and, my lord, after enumerating a complete scientific empirical data available that 57.6% are BCs and 42% is reservation which is made, my lord, and the law is made to that extent, which law, my lord, pursuant to the honorable judgment of the Honorable Supreme Court, is an act, my lord, of the state. My lord, at this stage, at the stage of interlocutory, my lord, which your lordships are hearing at the interlocutory stage, my lord, no interim order, my lord, to stultify, my lord, that is what the Justice Singhvi said, my lord, in this judgment, my lord, which your lords, stultifying the election process would not be correct at this stage, my lord.
Item 159, my lord, first matter.
My lord, insofar as Satyanarayan Reddy, my lord, which was brought to your lordship's notice that it has to be published, my lord, would not apply in this case. My lord, there, my lord, it was a commission which conducted a survey. That survey, my lord, the court said you ought to have published it. My lord, insofar as this case is concerned, now before your lordships is a My lord, a demographic survey conducted across the state, empirical data collected on the basis of such a survey, my lord, which has fixed the population of the BCs at 57.6% and the reservation provided at 42%, cannot be interfered, my lord. At this stage, my lord, till your lordships will hear at the final stage to stultify the election process.
Yes, learned advocate Mr. Ravi Verma.
May I please? My learned predecessors have substantially covered most of the aspects on which I wanted to speak. I would only touch upon one vital issue which has not been so far addressed. Now, what is the foundation for this 50% rule? I request the court to kindly permit me to show that. Kindly take Balaji, M.R. Balaji. Balaji is the decision which laid the foundation for that the provision which is authorized to be made is a special provision. It is not a provision which is exclusive in character, so that in looking after the advancement of those classes, the state would be justified in ignoring altogether the advancement of the rest of the society. Can you mark it, sir? This is important. It is because the interest of the society at large would be served by promoting the advancement of the weaker elements in the society that Article 15(4) authorizes special provision to be made. But if a provision which is in the nature of an exception, I repeat, which is in the nature of an exception, completely excludes the rest of the society, that clearly is outside the scope of Article 15(4). It would be extremely unreasonable to assume that in enacting Article 15(4), the Constitution intended to provide that where the advancement of backward classes or the scheduled caste, scheduled tribes was concerned, the fundamental rights, kindly mark it, this is important, the fundamental rights of the citizens constituting the rest of the society were to be completely and absolutely ignored. So therefore, this 50% cap was invented by the judiciary in order to safeguard the fundamental right of the rest of the citizens, other than the scheduled caste, scheduled tribes and the backward classes. In this backdrop, I asked this question myself. What is the fundamental right of the petitioners or the rest of the society that is affected by the reservations now provided, which constitute 67%? The learned Advocate General has elaborately placed before the court the findings of the survey. Kindly permit me to reiterate this. 10.43% of the society belongs to scheduled tribes. 17.42% of the society belongs to scheduled castes. The backward classes constitute, my learned predecessor said, 57.6%. I stand corrected. I was given the figure 56.36. Whatever is the correct figure, it is either 56 or 57. So in other words, just about 15% of the population is outside the reservation. The other castes, other than the scheduled caste, scheduled tribes and backward classes, constitute only 15% of the state's population. Now this 15% of the state's population is given 33% because the extent now provided is 67%. 42% for the backward classes, 15% for the scheduled caste, and 10% for the scheduled tribe. So 67% is the percentage of reservation provided. And what is excluded is 33% of the seats and 33% of the officers of the panchayats and the municipalities are left for 15% of the forward castes, if I may use that language, who are not coming under the backward tag. So this they complain is excessive reservation. Now, having told that the entire foundation for the limitation of 50% was the fundamental right under Article 15(1), because 15(4) was considered as an exception, sir. This is very important. 15(4) was considered as an exception to 15(1). I would request the court to kindly permit me to show what happened to this exception rule. Kindly permit me to show from Indrasani, 1992 Supplement 3 SCC, page 217.
Don't know whether I take. Yes.
Now, kindly come to question number 6 that was considered by the court, a 9-judge bench decision. Para 804, page 731. Page 731 may be considered.
Next volume.
Very interestingly, what happened was Balaji invented this rule for education under 15(1). Now this was carried forward to services under 16(4). Now kindly come to page 731.
730.
Page 73. Page 731. Question number 6 consisted of 4. To what extent can reservation be made? Whether 50% rule initiated in Balaji a binding rule? B. Whether the 50% rule, if any, is confined to reservations made under 16(4), or whether it takes in all types of reservations. C. Further applying 50% rule, whether a year should be taken. All these three are not relevant. I will not trouble the court. Kindly come to the last paragraph, last question. Was Devdasan correctly decided? Why did the court consider this? Because when Balaji said 15(4) is an exception to 15(1), Devdasan extended it to services and said 16(4) is also an exception. Now kindly see 804 Balaji is referred. I will not trouble the court. Then Devdasan is referred in the next page, 732. Then the subsequent judgments in N.M. Thomas is referred. And thereafterwards, what is important to be shown is at page 739, paragraph 816. Now, Devdasan is referred to and quoted 816, page 738, para 816. It is quoted. I will not trouble the court. It only says Balaji, the majority speaking through Mudavkar, upheld the contention of the petitioners and struck down the rule purporting to apply the principle of Balaji. Now that paragraph is set out. I will not trouble the court. Kindly come to page 817.
817.
Para 817, next page, 739.
Yes.
Last term D may kindly be seen. Only one sentence I will point out. We may also point out that the premise made in Balaji and reiterated in Devdasan to the effect that class 4 is an exception to class 1 is no longer acceptable. Kindly mark it, sir. Is no longer acceptable, having been given up in Thomas. It is for this reason that in Karmachari Sangh, Krishna here explained Devdasan in the following words. I will not trouble the court that. Ultimately, kindly come to the next page, 740, opening sentence. 740, Classitum A, opening sentence.
Yes, yes.
We are in respectful agreement in the above statement of law. Accordingly, we overrule the decision of Devdasan.
Yes.
So, Balaji exception rule is given a go by. Devdasan limitation of 50% is given a go by. And therefore, the court said this is not an inflexible rule. It has already been read out. I will not trouble the court. Now, here is a case where there is no fundamental right to any of the petitioners. Right to contest elections or right to vote in an election is not a fundamental right. It is so well settled right from Ponnaswamy's case, reiterated in Jyoti Basu and reinforced in Kuldeep Nayak. That right to vote is not a fundamental right. It is not even a constitutional right. It is not even a common law right. That is what the Honorable Supreme Court has repeatedly held. Having said that, now what is it that is being complained by the petitioners? Which right? Is it a fundamental right? Is it a common law right? Why do they say it is reservation is excessive? Or why do they say 50% has to be imposed? Now that is purely because Krishnamurti says 50% rule. Now it has already been read over. I'll request the court kindly just to formulate this position that Krishnamurti judgment is not based on any rule of the Constitution. Not a single provision is quoted as laying down a limitation on reservations to be provided. So on what principle has the court invented this principle of 50% rule? Since the paragraphs are already elaborately read out, the learned Advocate General also today read out paragraph 63 to 67.
Yes.
So there is no fundamental right to vote, there is no fundamental right to contest. Therefore, no right of any candidate, much less a forward caste candidate, is affected by these reservations, is my very respectful submission. So Krishnamurti rule has to be considered in this context, because it is not based on any provision of law or any provision of the constitution. It is a principle invented by the court without there being any foundation of a constitutional provision which enables to do that. Now, the learned Advocate General has already shown 243D6 and 243D6. They do not lay down any kind of a limitation on the plenary power of the legislature to provide reservation in favor of the backward classes. Therefore, imposing a reservation of 42% and still leaving 33% unreserved for the benefit of 15% of the state's population, my very respectful submission is not to be considered as arbitrary, excessive, or over reserved. That being the position, now the court was pleased to ask yesterday my learned predecessor Dr. Singhvi, Gauli has specifically laid down 50% as a rule. I bow down to that observation. I respectfully agree, Gauli has laid down. But Gauli has simply followed Krishnamurti. But even after laying down Krishnamurti, I would request the court to kindly permit me to show the very same judges what they have done in S.V. Joshi's case. Sir, Tamil Nadu provided 69% reservation. And that 69%, 69% reservation was provided. And this came to be challenged before the Honorable Supreme Court under Article 32. Sir, the judgment is reported at page 41 of 2012 7 SCC. S.V. Joshi versus State of Karnataka. All the writ petitions were disposed of, both of Karnataka as well as the Tamil Nadu, this thing. Kindly come to page 43. Page 43. The short question which arises for determination in these writ petitions is whether the quantum of reservation provided for in Tamil Nadu backward classes, scheduled castes and scheduled tribes reservation of seats in educational institutions and of appointments or posts in the services under the State Act 1993 is valid. The impugned act received the presidential assent on 19/7/1994. Subsequent to the filing of the above writ petitions, Articles 15 and 16 of the Constitution have been amended by Constitution 93rd Amendment Act 2005, Constitution 81st Amendment Act 2000 respectively, which amendment acts have been the subject matter of subsequent decisions of this court in M. Nagaraj versus Union of India and Ashok Kumar Thakur versus Union of India, in which, inter alia, it has been laid down that if a state wants to exceed, kindly mark it, sir, this is important. If the state wants to exceed 50% reservation, then it is required to base its decision on the quantifiable data. In the present case, this exercise has not been done. Therefore, keeping in mind the set parameter, we direct the state to place the quantifiable data before the Tamil Nadu State Backward Classes Commission. And on the basis of such quantifiable data, amongst other things, the Commission will decide the quantum of reservation. we are informed by the learned Solicitor General that such data is in the form of reports which are subsequently prepared is already available. Consequently, these writ petitions stand disposed of with a direction to the state government to revisit and take appropriate decision in the light of what is stated above. It needs to be mentioned that the interim orders passed by this court from time to time in relation to admission to educational institutions shall continue to be in force and in operation for a period of 1 year from today. So, without interfering with the Act, in other words, upholding the provisions of the Act, the state was directed to collect the quantifiable data to justify 69% reservation, and that has been done. So therefore, the Supreme Court itself has observed, kindly mark it, this bench was also presided over, was also consisting of the very judges, perhaps who were part of Krishnamurti, and they directed that 69% reservation would be justified. And they have rightly interpreted M. Nagaraj and Ashok Kumar, both are constitution bench judgments, saying that if the state wants to exceed 50%, then it has to be based on quantifiable data. So with this, similar direction was issued at para 13, next page, 44, page 44, to state of Karnataka also, to collect the quantifiable data to justify 73% reservation that was put. So what I want to drive home is
Yes.
so my answer to the weighty observation of this honorable court about Gowdy's case, which is based on Krishnamurti, is based on Janhit Abhiyan's case, which has said this is not an inflexible rule. 50% is not an inflexible rule. It can be breached, provided there is no. So therefore, Krishnamurti and Gowdy were prior to Javdi. I request the court to kindly permit me to show. The latest judgment in the field is the Constitution Bench judgment in Janhit Abhiyan, which was pronounced on November 7, 2022, long after Krishnamurti and Javdi were published or pronounced. So therefore, the law laid down by Krishnamurti and Javdi is no longer good law in the light of the declaration made, law laid down in Janhit Abhiyan in 2023, 5 SCC, page 1. If
Very
not,
well.
if not per incurium, because they are not based on any constitutional provision, much less based on fact, much less in ignorance of the fact that
Very well
right
put.
to vote, right to contest elections is not a right guaranteed as a fundamental right or as a constitutional right.
Yes,
One last but not the least submission is the other weighty observation made by the Honorable Court. If it is a deemed approval, as laid down in Tamil Nadu government case, is there a publication? My learned predecessors have already very effectively met that position. I would only add this to say that when there is a deemed approval, it is an appropriate case where there should be a deemed publication also, because the bill was published, the bill was debated, and the bill was uh, placed on the floor of the House. So a deemed approval would also be a deemed publication is my very respectful submission.
yes,
So with these submissions, I very respectfully adopt the arguments of my learned predecessors and
yes. Take down.
great.
Take down. We have heard learned counsel for the petitioners and learned counsels so and so for the state for the last 2 days at length on the interim prayer made in these batch of writ petitions. Stop. Para. 4 weeks time is allowed to the state to file counter affidavit. 2 weeks time thereafter is allowed to the petitioners to file reply if so advised. In the meantime, there shall be interim stay of the impugned notification. All implead applications are allowed. We'll indicate the reasons. Reasons will follow. Give it. We'll indicate the detailed reasons.
My written submissions have been given.
Or the rest of the society that is affected by the reservations now provided, which constitute 67%. The learned Advocate General has elaborately placed before the court the findings of the survey. Kindly permit me to reiterate this. 10.43% of the society belongs to scheduled tribes. 17.42% of the society belongs to scheduled castes. The backward classes constitute, my learned predecessor said, 57.6%. I stand corrected. I was given the figure 56.36. Whatever is the correct figure, it is either 56 or 57. So in other words, just about 15% of the population is outside the reservation. The other castes, other than the scheduled castes, scheduled tribes and backward classes, constitute only 15% of the state's population. Now this 15% of the state's population is given 33% because the extent now provided is 67%. 42% for the backward classes, 15% for the scheduled castes, and 10% for the scheduled tribe. So 67% is the percentage of reservation provided. And what is excluded is 33% of the seats and 33% of the officers of the panchayats and the municipalities are left for 15% of the forward castes, if I may use that language, who are not coming under the backward tag. So this, they complain, is excessive reservation. Now, having told that the entire foundation for the limitation of 50% was the fundamental right under Article 15(1), because 15(4) was considered as an exception, sir. This is very important. 15(4) was considered as an exception to 15(1). I would request the court to kindly permit me to show what happened to this exception rule. Kindly permit me to show from Indrasani, 1992 Supplement 3 SCC, page 217.
Yes.
Now kindly come to question number 6 that was considered by the court, a 9-judge bench decision. Para 804, page 731. Page 731 may be considered.
Next volume.
Very interestingly, what happened was Balaji invented this rule for education under 15(1). Now this was carried forward to services under 16(4). Now kindly come to page 731.
730.
Page 73. Page 731. Question number 6 consisted of 4. To what extent can reservation be made? Whether 50% rule initiated in Balaji a binding rule? B. Whether the 50% rule, if any, is confined to reservations made under 16(4), or whether it takes in all types of reservations. C. Further applying 50% rule, whether a year should be taken. All these three are not relevant. I will not trouble the court. Kindly come to the last paragraph, last question. Was Devdasan correctly decided? Why did the court consider this? Because when Balaji said 15(4) is an exception to 15(1), Devdasan extended it to services and said 16(4) is also an exception. Now kindly see 804 Balaji is referred. I will not trouble the court. Then Devdasan is referred in the next page 732. Then the subsequent judgments in N.M. Thomas is referred. And thereafterwards, what is important to be shown is at page 739, paragraph 816. Now, Devadasan is referred to and quoted 816, page 738, para 816. It is quoted. I will not trouble the court. It only says Balaji, the majority speaking through Mudavkar, upheld the contention of the petitioners and struck down the rule purporting to apply the principle of Balaji. Now that paragraph is set out. I will not trouble the court. Kindly come to page 817.
817.
Para 817, next page, 739.
Yes.
Last term D may kindly be seen. Only one sentence I will point out. We may also point out that the premise made in Balaji and reiterated in Devadasan to the effect that class 4 is an exception to class 1 is no longer acceptable. Kindly mark it, sir. Is no longer acceptable, having been given up in Thomas. It is for this reason that in Karmachari Sangh, Krishna here explained Devadasan in the following words. I will not trouble the court with that. Ultimately, kindly come to the next page, 740, opening sentence. 740, Classitum A, opening sentence.
Yes, yes.
We are in respectful agreement in the above statement of law. Accordingly, we overrule the decision of Devadasan.
Yes.
So, Balaji exception rule is given a go by. Devadasan limitation of 50% is given a go by. And therefore, the court said this is not an inflexible rule. It has already been read out. I will not trouble the court. Now, here is a case where there is no fundamental right to any of the petitioners. Right to contest elections or right to vote in an election is not a fundamental right. It is so well settled right from Ponnaswamy's case, reiterated in Jyoti Basu and reinforced in Kuldeep Nayak. That right to vote is not a fundamental right. It is not even a constitutional right. It is not even a common law right. That is what the Honorable Supreme Court has repeatedly held. Having said that, now what is it that is being complained by the petitioners? Which right? Is it a fundamental right? Is it a common law right? Why do they say it is reservation is excessive? Or why do they say 50% has to be imposed? Now that is purely because Krishnamurti says 50% rule. Now it has already been read over. I'll request the court kindly just to formulate this position that Krishnamurti judgment is not based on any rule of the Constitution. Not a single provision is quoted as laying down a limitation on reservations to be provided. So on what principle has the court invented this principle of 50% rule? Since the paragraphs are already elaborately read out, the learned Advocate General also today read out paragraph 63 to 67.
Yes.
So there is no fundamental right to vote. There is no fundamental right to contest. Therefore, no right of any candidate, much less a forward caste candidate, is affected by these reservations, is my very respectful submission. So Krishnamurti rule has to be considered in this context, because it is not based on any provision of law or any provision of the constitution. It is a principle invented by the court without there being any foundation of a constitutional provision which enables to do that. Now, the learned Advocate General has already shown 243D6 and 243T6. They do not lay down any kind of a limitation on the plenary power of the legislature to provide reservation in favor of the backward classes. Therefore, imposing a reservation of 42% and still leaving 33% unreserved for the benefit of 15% of the state's population, my very respectful submission is not to be considered as arbitrary, excessive, or over reserved. That being the position, now the court was pleased to ask yesterday my learned predecessor Dr. Singhvi, Gowli has specifically laid down 50% as a rule. I bow down to that observation. I respectfully agree, Gowli has laid down. But Gowli has simply followed Krishnamurti. But even after laying down Krishnamurti, I would request the court to kindly permit me to show the very same judges what they have done in S.V. Joshi's case. Sir, Tamil Nadu provided 69% reservation. And that 69%, 69% reservation was provided. And this came to be challenged before the Honorable Supreme Court under Article 32. Sir, the judgment is reported at page 41 of 2012 7 SCC. S.V. Joshi versus State of Karnataka. All the writ petitions were disposed of, both of Karnataka as well as the Tamil Nadu, this thing. Kindly come to page 43. Page 43. The short question which arises for determination in these writ petitions is whether the quantum of reservation provided for in Tamil Nadu backward classes, scheduled castes and scheduled tribes reservation of seats in educational institutions and of appointments or posts in the services under the State Act 1993 is valid. The impugned act received the presidential assent on 19/7/1994. Subsequent to the filing of the above writ petitions, Articles 15 and 16 of the Constitution have been amended by Constitution 93rd Amendment Act 2005, Constitution 81st Amendment Act 2000, respectively, which amendment acts have been the subject matter of subsequent decisions of this court in M. Nagaraj versus Union of India and Ashok Kumar Thakur versus Union of India, in which, inter alia, it has been laid down that if a state wants to exceed, kindly mark it, sir, this is important. If the state wants to exceed 50% reservation, then it is required to base its decision on the quantifiable data. In the present case, this exercise has not been done. Therefore, keeping in mind the set parameter, we direct the state to place the quantifiable data before the Tamil Nadu State Backward Classes Commission. And on the basis of such quantifiable data, amongst other things, the Commission will decide the quantum of reservation. We are informed by the learned Solicitor General that such data is in the form of reports which are subsequently prepared is already available. Consequently, these writ petitions stand disposed of with a direction to the state government to revisit and take appropriate decision in the light of what is stated above. It needs to be mentioned that the interim orders passed by this court from time to time in relation to admission to educational institutions shall continue to be in force and in operation for a period of 1 year from today. So, without interfering with the Act, in other words, upholding the provisions of the Act, the state was directed to collect the quantifiable data to justify 69% reservation, and that has been done. So therefore, the Supreme Court itself has observed, kindly mark it, this bench was also presided over, was also consisting of the very judges, perhaps who were part of Krishnamurti, and they directed that 69% reservation would be justified. And they have rightly interpreted M. Nagaraj and Ashok Kumar, both are constitution bench judgments, saying that if the state wants to exceed 50%, then it has to be based on quantifiable data. So with this, similar direction was issued at para 13, next page, 44, page 44, to state of Karnataka also, to collect the quantifiable data to justify 73% reservation that was provided. So what I want to drive home is
Yes.
so my answer to the weighty observation of this honorable court about Gowdy's case, which is based on Krishnamurti, is based on Janhit Abhiyan's case, which has said this is not an inflexible rule. 50% is not an inflexible rule. It can be breached, provided there is no. So therefore, Krishnamurti and Gowdy were prior to Javdi. I request the court to kindly permit me to show the latest judgment in the field is the Constitution Bench judgment in Janhit Abhiyan, which was pronounced on November 7, 2022, long after Krishnamurti and Javdi were published or pronounced. So therefore, the law laid down by Krishnamurti and Javdi is no longer good law in the light of the declaration made, law laid down in Janhit Abhiyan in 2023, 5 SCC, page 1. If
Very